essentially, my lord, I just want to indicate how I intend to proceed. First, my lord, what is the issue?
Certainly, sir.
What is the narrow issue before my lords? Secondly, my lord, I will show your lordships the 246 Law Commission report from which all these disputes began. Thirdly, my lord, there are actually only 4 judgments which are in play. TRF Energo, my lord, Perkins Eastman, Poor and Voestalpine. These are the 4 judgments. I'll place those 4 judgments and then, my lord, I'll make my submissions. My lord, the issue is this. The other side says that one of the main aspects of arbitration is party autonomy and least intervention. They say that an agreement has been concluded with a particular procedure. They say the court should not interfere. This is broadly, my lord, the submission on the basis of party autonomy. My lord, the issue is whether a panel which is unilaterally appointed by one party, whether such a clause is valid in law, my lord, where one party unilaterally, my lord, and I'm using the language of one of these foreign judgments, unilaterally controls the pool of potential arbitrators, is such a clause valid under our law? And my lord, our submission will be, no doubt party autonomy is very important. No doubt there should be least court intervention, but there is a higher principle, namely arbitration is really a substitute. It is nothing, my lord, so fancy. You need a fair, independent and impartial tribunal, because ultimately the way the act operates, the challenge is limited. If you do not have a fair, independent and impartial tribunal, then, my lord, the consequences, whichever way it goes, are problematic.
Now, if a clause which gives unilateral right to one party to control the appointment of an arbitrator is invalid,
is concluded.
Right. And there is a clause to that effect. Then does the court have the jurisdiction to then re-tailor the clause to say that, well, the appointment process should be so modified so as to make it equitable or consistent with the broader principles of arbitration? Or does the court have to then accept it or reject it as it stands?
My lord, the answer lies straight away in 11.8. As amended, what the court then does is, my lord, it can deviate from the agreed procedure. In fact, Lombardy uses the word ignore. My lord, it can deviate from the procedure and ensure that there is an impartial tribunal. So, my lord, in all these cases, what has happened is, instead of the court tweaking the procedure, the court appoints an independent arbitrator. Rather than, my lord, trying to play around with the panel and tweak it, our submission is that because of 11.8 read with 12.5 and my lord, in fact, the language used in some of the judgments is the main purpose of 11.8 is to ensure an impartial tribunal. So where the court finds that the tribunal, that the clause is, my lord, tilted, one-sided, imbalanced, then the court will step in under 11.8.
Now, if there is no arbitration agreement, the court cannot hoist an arbitration on a party.
No.
Right?
Right, correct.
However much that might be in accordance with the move for ADR, etc. If there's no arbitration agreement, you cannot hoist an arbitration. Can a party which has then framed a clause which obviously is completely biased in favor of one party say that, look, but for this clause, I would have not agreed to arbitration?
Lord, then the principle there.
Then that argument be heard from such a party.
Right. My lord, there the principle of severability will apply. There is also law to that effect, to saying that you in fact actually did agree to arbitration, only that portion of the clause which has an unbalanced tribunal will be, my lord, blue lined out. That would be our submission. So I would submit, my lord, all these are all larger questions. So far as core is concerned, because that clause your lordships will see, that clause is so tilted.
And what if that party has said in the arbitration agreement, we agree to arbitration only on the condition that I will appoint an arbitrator?
There's a gray area there. There are such clauses. our court has held that despite such clauses, you can go ahead, but there is a gray area there. I may not be able to go that far. There are clauses which say, unless this procedure is followed,
There'll be no
I
other
do not agree to arbitration. Then your lordships may have to respect party autonomy to that extent. But that is not the language in 64 as we have it here. So, my lord, this is the limited
So
scope.
your contention then is that if there is an arbitration agreement by virtue of which absolute control is given to one party over the appointment process, then the court should treat it as one, that parties have agreed to arbitration as a procedure for resolving disputes, one.
Right.
Two, since you have agreed to a procedure for resolving disputes through arbitration, that part of the clause which confers exclusive right on one party is
Is
severable.
invalid. And you
Three,
and
the
three,
court should treat it as one, that
appoint
parties
an
have
independent tribunal.
agreed to
My lord,
arbitration as a.
yes, 2 and 3 is later, my lord. We are still stuck at actually 1 because 1 is being debated.
Now, should we look at the statute
Right.
and then go to your cases?
Right. First, your lordship, before the statute, I would request your lordship to see few paragraphs of the Law Commission report, then the statute. It will be in sequence because
Let's see the statute first,
All
and
right.
then we'll go back to the law.
All right.
Then we'll understand
very
how it
well.
was.
My lord, 7 or 8 provisions of the statute. It's in volume. It's in at page 101.
Of
Volume 3. Volume 2. Where is our? No, this is the statute after the 2015 amendment, because we are now only post the 2015 amendment. Now, my lord, the reason I am showing some sections is only to establish the proposition that there are some provisions of the Arbitration Act which are mandatory. There is no general party autonomy. Some provisions, as per the commentary and as per the travaux, are mandatory. So those cannot be derogated from. That's the language of the Act and that's the language of the commentary. Lordships may first see section 4. Few sections. 101, my lord, it starts, volume 2. Is there a tab? Well, let me first see 4, which is at page 107. Well, the only reason I'm showing it, I'll show some commentary on this later, is this is the waiver provision. It has some relevance in our case. A party who knows that any provision of this Act from which the parties may derogate. So, there are provisions in the Act from which you cannot derogate. The word derogate is used in 2 sections of Part 1, Section 4 and Section 34. So you cannot, so my lord, this section and Article 4 commentary, which I will show later, recognizes there are some provisions which cannot be derogated from. Then your lordship sees 5, which is the extension of jurisdiction, just for the sake of completion. Then please straight away come to section 11, which is at page 110. Not 11 is titled Appointment of Arbitrators. This is based on Article 11 of the model law. And what the other side relies on, my lord, is 2. Subject to subsection 6, the parties are free to agree on a procedure for appointing arbitrator. Lordships have seen that. Then 6 is where the appointment is made. When an application is filed, parties to request the Supreme Court or the High Court. 6A, your lordships have seen in a different context, my lords, earlier in the NN Global saga. But please come to 8, because we rely, my lord, on 8. 8 is post-amendment, and therefore the Law Commission report becomes relevant insofar as 8 is concerned. The Supreme Court, or as the case may be the High Court, or the person or institution designated by such court, before appointing an arbitrator, shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1, 12(1), and have due regard to. So, this is something which is deviant from the procedure. and have due regard to qualifications required for the arbitrator by agreement of the parties, and B, the contents of the disclosure and other considerations as are likely to secure the appointment of an independent and impartial arbitrator. So, my lord, 11.8, and it has been judicially also held by this honorable court, by your lordships, that you are required, I would not even say, my lord, you are, it's a discretion, you are required to deviate from the procedure to ensure that the tribunal that you appoint under 11, the court, is an independent and impartial tribunal. So, my lord, 11.8 is crucial for our purposes. I will show some, the Law Commission report on that, and, my lord, some commentary on that. This, in my view, is something which core has completely missed. 11.8 has not been noticed. Then, my lords, may go to section 12, which is at page 113. 112. This will be elaborately argued by, my lord, various others here. I'm just touching on it. 12 is grounds for challenge. This has been amended drastically after the 2015 amendment in view of the Law Commission report. 12 has been substituted. My lord, various disclosures are to be made. And then important is 12.5 at page 113. This is de jure ineligibility. Notwithstanding any prior agreement to the contrary, any person whose relationship with parties or counsel or the subject matter of the dispute falls under any of the categories specified in 7th schedule shall be ineligible to be appointed as an arbitrator, provided parties may, subsequent to disputes having been arisen between them, waive the applicability by express agreement in writing. So, 12.5 talks of about 7th schedule ineligibility. The lordships have interpreted this in a number of judgments with this proviso. So, 12 has to be read with 11 because 11 now 8 requires a disclosure by a prospective arbitrator, which wasn't there earlier. So now when the matter comes, say, before your lordships under section 11 or before the High Court under section 11, if such a panel is to be operated, they will have to make a disclosure of whatever relationship they have. And independent of that disclosure, your lordships will ensure that there is an impartial and independent tribunal. So the moment that burden is cast upon the on the court, my lord, then there is a problem with these panels, which are unilateral. There's no problem, my lord, with a panel of an institution or an independent panel. So, my lord, 12.5, 13 is the challenge procedure. I'm not troubling your lordships. 14 is failure or impossibility to act. That is de jure. Your lordships are familiar with that. Then please now come to one other portion. In fact, I was very happy that the learned SG had highlighted that portion in his written submissions because we were also intending to rely on it. Please come now to page 115. This is something which has been hinted at in some of the judgments, but not spelt out. Well, chapter 5 is sections 18 to 27. Two sections here are crucial to my submission, my lord. First is 18. Conduct of arbitral proceeding 18. Equal treatment of parties. The parties shall be treated with equality. This is one part. And each party shall be given full opportunity to present this case. Noted in the learned SG submissions as the Magna Carta of arbitration. And, my lord, which we will show that this equal treatment principle applies even at the stage of the composition of the tribunal. And that will make good, my lord. So,
of course, the chapter heading says conduct of arbitral proceeding.
But the commentary, my lord, and particularly section 21 has to be read with 18. 21 suggests, my lord, that the commencement of the arbitral proceedings starts when the request is given. Your lordships are familiar with 21. So the appointment of the arbitral tribunal actually comes after that.
Absolutely.
And, my lord, the idea is simple. whatever contractually you've agreed. But once you are before a quasi-judicial body or a substitute for the court, then all rules of fair play have to be there. You should be before somebody who's independent and impartial, and you should be treated equally. So, my lord, our submission is 18 squarely applies, and we'll, my lord, show that. So, this is one separate portion of the act which has really squarely not been considered. It's been hinted at in a couple of judgments, but it's not been considered. 18 and 21. And then, my lord, just to complete this, please now come to 34. 34 is at page 121. As your lordships know, there are two limbs to 34. One is party and one is, my lord, public policy. The two portions I want to show, which are of some relevance, my lord, is 34.2a2 and 34.2a5. An arbitral award may be set aside by the court only if the party making the application establishes on the basis of the record that the arbitration agreement is not valid under the law in force, law to which the parties have subjected, or failing any indication under the law for the timing in force. So, arbitration is not valid under Indian law as a ground for setting aside an award. And more, my lord, pertinently, 34.2a5. There's some very interesting commentary on 2a5. The composition of the arbitral tribunal, which is what we are, my lord, now looking at, or the arbitral procedure was not in accordance with the agreement of the parties. This is party autonomy, unless such agreement was in conflict with the provision of this part from which the parties cannot derogate. So, my lord, this is the second place in the act where the word derogate is used. So, even if you have an agreement between the parties and that agreement derogates from a mandatory provision of part 1, the award can be set aside, or failing such agreement not in accordance with this part. No, that's the other position where there is no arbitration clause. What I must mention here, there is a 3-judge bench judgment which is a little problematic. I'll come back to it. So, these are the sections which are relevant for the purposes of our limited issue of unilateral appointment of a panel. Now, my lords, before I go to the 4 judgments, may I now just invite your lordship.
Mr. Banerjee, just before we leave this statutory provisions, this chapter 5 is conduct of arbitral proceedings.
Correct.
Now, only by virtue of what is contained in section 21, you are saying that it will also relate to not just conduct of the proceedings, but also the commencement and composition of the tribunal.
My lord, I will show your lordship some commentary on this very Article 18, which suggests that the composition is also covered by 18. The heading, no doubt, seems to suggest.
Yeah, heading is a little misleading.
But
yes, what you are trying to
is
say.
Absolutely right. But I will show, that's why I wanted to mention, my lord, I will have to establish that this provision is relevant for the composition stage. And that, my lord, we will establish by the relevant, my lord, material.
Now, which are the non-derogable provisions of the part in regard to composition?
Right. Now, my lord.
That's section 12?
My lord, I would say
11.8,
11.8, 12, 18 for our purposes. My lord, in fact, there was a very long debate in the working group. They wanted to make a list, but they didn't make ultimately they didn't make a list. They said it is to be this thing. There are 2 judgments of our court, one on 12.5 in Harsak and one on section.
Forget all the judgments because we are a constitution bench. You argue as a matter of first principle.
So, my lord, 12.
Let me look at which judgments fall in line with what we are
judgments.
inclined.
I understand. 12.5, my lord, is mandatory.
12.5 is mandatory.
12.5 is mandatory. 18 is mandatory.
12.5.
12.5 read with 11.8 because, my lord, 11.8 refers to 12. So 12.5 read with 11.8 and 18, according to my lord, submissions, are mandatory, and the commentary also says so. There are various other provisions which are mandatory, but it is not necessary to enumerate the
Now,
complete.
I'll pose to you a hypothetical. Any arbitrator cannot fall within the degrees of prohibited relationship, if we can use that expression, which has been spelled out in the 7th schedule. Now, what if one of the clauses, what if the arbitration agreement provides that one of the parties shall appoint? Can such a clause be made consistent with 12.5 by saying that the persons whom that party appoints should not in any way be in breach of the 7th schedule? Will that then be a provision which will be in conflict?
Mulot, the answer there is, Mulot, unilateral.
Is unilateral appointment itself by itself
That is
contrary to the provisions of the Act?
Yes, Mulot, because
one is that any appointment which of an arbitrator who is in conflict with the 7th schedule is absolutely a non-derogable provision of the statute. But does the Arbitration Act itself frown upon unilateral appointment per se?
Well, Lord, that is how your lordships have interpreted it in two judgments.
No, but forget the judgments for a moment.
Well, Lord,
where did we get
is
that? Where do we identify the?
Yes. Well, Lord, I identified it, my lord.
Can trace it only to 18.
I identify it in this fashion, my lord. It flows from the amendments made pursuant to the Law Commission report, which frowned on unilateral appointments. The Law Commission, therefore, my lord, I want to show that, and I want to show the amendment, particularly 11.8.
So now that you have formulated shown us these statutory provisions, what you can do is this: you now formulate your points, you formulate your submissions. Then we will go into then we go to the 4 judgments, the Law Commission report. So you can just formulate your submissions now.
Right, my lord. My submissions are, my lord, I am only on panel because there is no challenge subject to correction.
You are only on
panel, my lord, unilateral panel. My lord, because I know your lordship has asked me the question whether unilateral appointments are, my lord, are eschewed generally or not. But
suppose the railways, for instance, says that, look, we will have a panel of people who are not connected with us at all. We have a panel.
Absolutely. My lord, I have to answer that.
We have a panel of retired judges.
We have a panel of impeccable, my lord, integrity,
etc. Is that permissible under the statute?
Right. My lord, according to us, no. And I will formulate 4 or 5, my lord, under 4 or 5 heads.
All right. Now, why don't you just take the next 3 or 4 minutes and formulate your submissions? You can we've asked you a question right at the beginning, but it will help us to formulate your points. If you want to read your written submission, we can read your written submission.
That will come to there are 4 grounds on which, 4 different jurisprudential grounds on which.
All right, just formulate that.
There are 4 jurisprudential. My lord, one is that a panel unilaterally appointed by one party.
One thing.
Control, you want to mention control? My lord, the better word would be unilaterally controlled by one party. A panel unilaterally controlled by one party, my lord, would fall foul of section 11.8 read with section 12, in that it would not be independent and impartial. This is the first, my lord, first ground. 11.8 read with 12.
In that it will not be
an independent and impartial tribunal. It may be impartial, but it is not independent. It will not be an independent and impartial tribunal, which is a non-derogable, my lord, facet of arbitration jurisprudence. It has to be independent and impartial. Otherwise, the entire, my lord, edifice collapses.
But independence, is it a quality in the arbitrator, or is it in the process of appointment? It's
in the process, my lord. I will show, my lord. There's a very nice paragraph. I will show, my lord. Independence is qua, my lord, the the clause, my lord. We are not on individual arbitrator.
Your argument could be really that you must avoid an appearance of bias, not just actual bias.
Right, my lord. The actual bias we are
Therefore,
not,
you don't
we are
have
not
to
alleging.
go so far as to say that, well, I'm aggrieved because this particular panel which they have appointed is suffering from lack of independence. But the fact that one party controls it
Is
does
I
not
will show, my lord.
satisfy the principle that there must be it must generate confidence in the arbitrating parties. It must generate a sense of credibility.
I have four
We
heads
say in a
under
court,
which
it's
your
not just
lordship will.
actual bias, it's an appearance of bias which must be avoided.
One is the bias argument. My lord, I am on the
Independence argument.
independence argument because if your lordship sees 11.8, my lord, one is disclosure, bias, etc. And just show 11.8 again.
It will not be an independent panel.
Yes. So, my lord, this is an important question, my lord, because let me not put it very bluntly.
And and one more sentence you can add there in your first proposition, that a panel which is exclusively controlled by one party, according to you, suffers from a lack of independence.
Right. This is, my lord, proposition 1.
For that, you will have to draw in from 18.
18 is
You may be
separate.
able to draw in.
18 is one more. This is, my lord, 11 read with
18 is limited in its scope.
18, my lord. 18 is, my lord. Secondly, any clause which, my lord, does not. Your lordship has that exactly the question Justice Roy put to me, limited in its scope, my lord. I will satisfy your lordship on that separately. The second limb, my lord, it's a second ground on which I put. There are various, my lord, four grounds we have formulated.
Independence may be also looked at from the perception, because now we're not talking about a lack of independence to challenge an award.
Correct.
All right. Just as when you challenge, say, a judgment of a court on the ground that the judge lacked independence.
Correct.
The threshold is very high. That the judge had some interest in the subject matter or was connected to the parties to the dispute, so on and so forth. But independence at the stage of composition is a matter of perception. Because you are entering into a judicial proceeding, which is arbitration is a substitute for a judicial proceeding. So when parties are entering upon arbitration, it is their perception of an independent adjudicator or lack of independence, which is crucial. Because you must create conditions which foster a sense of confidence in the process.
In fact, 3 phrases, my lord, have been.
Whether in fact that person was eventually independent or otherwise begs the question.
What happens in these cases, my lord, all the 4 cases before your lordships are railways and railways connected cases. From time immemorial, they have something called clause 64. The problem here is, my lord.
So independence at the stage of composition is not an objective test of whether someone would or would not be biased. But the perception of a party who is accepting,
correct. I am obliged.
That perception must be that of an independent adjudicator.
Absolutely. My lord, in fact, 3 phrases are used in judgments: major objective, paramount consideration, and important consideration. A paramount consideration is independence. Just show me. Of confidence so far as our arbitrators are concerned. If you have such a panel, the result both ways is bad. If the panel appointed by one set of one party decides in the favor of that party, the other party always has that lingering doubt that Mr. Banerjee was appointed on the railways panel, so therefore he has a predisposition.
No, but look at it from the side of the public sector.
The other problem.
Look at it we must look at both sides.
No difficulty.
A public sector organization always has this fear that look at what's happening in the arbitration.
Correct.
Will be taken
now
from around, we'll have a 20,000 crore award.
Now you see this one-sided panel story. Now the one-sided panel, Mr. Banerjee now gives an award in favor of the contractor. Now, immediately, my lord, all sorts of issues arise there, may be genuine. So, my lord, the solution is not a one-sided panel. The solution is staring in the face, my lord. The solution is an independent panel by an independent institution. That is why we are crying hoarse that we should have institutional arbitration. The problem is not the individuals in the panel. The problem is who makes the panel. The moment today, my lord, both ways you lose.
Not saying that we need independence and full stop. The problem is arising, what is the criteria? What are those principles on the basis of which we are going to determine that there is lacking of independence here?
My lord,
Everybody agrees that they have to be
the
independent.
very fact, let me put it this way, Manoj, the very fact that one party is appointing somebody, my lord, is unfortunately enough, because, my lord, what was arbitration? Arbitration was where both parties had confidence in the individual. Here you are basically putting up a list and asking one. So there will never be any confidence in that list of the other party. One of the articles said unloved and unappreciated panel. One party puts up a panel. My lord, please keep the distinction between, my lord, the process of appointment and the eligibility of individual arbitrators.
So your first point I have formulated, a panel unilaterally controlled by one party would fall foul of section 11(8) read with section 12. In that it will not be an independent panel. A panel appointed by one party will lack a degree of independence.
Correct.
That's the first point. What's the second
Even
point?
if impartial, my lord, I assume for a moment, my lord, impartiality, etc., will come in, my lord, when you have employees, retired employees. I am going one step further, assuming you have absolutely, my lord, respectable people.
What's the second proposition?
What's the next proposition?
My lord, the next is it will also fall foul of,
What will fall foul? Unilateral appointment.
yes, also fall foul of, my lord, the principle, the Magna Carta of equality between the parties. I'll satisfy your lordship.
Unilateral composition of a panel.
Yes,
It also violates 18.
18.
It violates 18.
Violates 18.
Level playing field.
Sorry, my lord.
Level playing field.
Level playing field. This is the logic, my lord, used by Justice Sikri also, level playing field. Justice Bhanumati also, same level playing field. So the sentence is there, the section is not there.
So you want to extend 18 to even appointment process?
My lord, I will show that there is material to show that it actually covers the appointment, the composition process. I will, it's not just my submission, my lord.
What's the next point?
Third point, my lord, which is, I would say 3A and 3B, my lord, is that such a clause, particularly in respect of PSUs, my lord, falls foul of 14 and unconscionability. A large number of judgments, my lord, some of which the learned SG has also referred to, is this sort of arrangement is unconscionable, contrary to section 23. There are a series of 10 US judgments. I will show only one. There's a chart the SG has given. I'll show one. So, these are broadly the reasons for which this sort of panel should not, my lord, be permitted to subsist. The band-aid solution is, and this is what the high courts are struggling with, a panel as in core may be bad because it's very restrictive, but if it is sufficiently broad-based, it may be okay. So, my lord, this is how
the degrees at all. You are just saying that, look, exit out.
The problem is today there are a series of judgments. Every time an 11 is filed, how many people are there? What are their qualification? Is 31 enough? Is 37 enough? What about 100? There is a Sarot panel. So this is a solution which came out of Voestalpine, and it's, in my respectful submission, my lord, it's a band-aid solution. Because even if there are 100 people, and even if they are, my lord, impeccable, there is always, my lord, I'm appointed to a panel by the railways. In the back of my mind, if I possibly decide in their favor, maybe I'll get another appointment. That may be a perception. I may be, in my mind, absolutely independent. We've had instances where people have been removed from panels.
Independent and impartiality is not in the degree.
It's not in the degree.
It is in its absoluteness.
And what you facially see, my lord. What do you see?
But is that your 3A point?
That's
What's your 3A? 3A is that.
3A, 3B, my lord, are unconscionability and Article 14. My lord, legally, I am putting.
To take what Brother Nasumai just said, that independence and impartiality
is not a matter of degree, my lord.
but of.
Well, it has to be facially judged.
But is an absolute. It is absolute.
It is absolute.
So therefore, even if theoretically the party which has unilateral control proceeds to prepare a panel which is otherwise absolutely, objectively independent.
Perfect.
The objection is not on whether those people who are put in the panel are
eligible,
otherwise
ineligible,
or ineligible.
It's
But
the
the
source.
appearance of the
It's the
process.
process, the source. If you cannot, it also flows from the other principle. If you cannot unilaterally appoint somebody, can you then have a panel of 100 from which I have to choose? The source is the problem. The problem is not the panel. The problem is the process. The problem is the person who presents you with the fait accompli.
All right, we've seen now all the provisions.
Right. All the provisions.
Your submissions are complete now. Anything else in
My
those?
lord, now I'll show the material, my lord. The
We'll go to
material.
material now.
The material. My lord, your lordships may first see the law commission.
Let's
Your
see.
lordships have not seen those 4 judgments. Am I required to show the?
Let's first see quickly the law commission, the material, and then we'll quickly look at the judgments.
Right.
The judgments at the end, because
Judgments at the end.
That's-
Right.
they are
Your lordships
persuasive.
don't want to be colored by
Exactly.
2 or 3
They are, of
judgments.
course, of persuasive authority. They are judgments of our
Correct.
courts. We'll look
Correct.
at them at the end.
My lord, may first see the law commission report because some paragraphs of that are very, very important.
Is that in the documents?
Where is my? Just a minute. Just give me a second. My lord, this is serial volume 4, page 2722. Serial number, tab number,
Compilation of documents, right?
compilation.
Volume 4A or 4?
4.
Page
2722 is tab number 8, but the only relevant paragraphs are from page 2756.
You must compliment the juniors who have prepared the compilation, are very well prepared.
Yeah.
Otherwise, I tell you what we have is compilation of judgments by Mr.
Yeah.
Gaurav Banerjee, compilation of judgments by Mr. Neeraj Kaul, compilation by Mr. Shashankar or whoever. So it's such a headache because when you start dictating a judgment, you have like 10 compilations. The idea is to have one compilation, which everybody puts their cases together, you know.
The system is working well.
The system
1,
is
2,
working
3,
well,
4.
actually. Yeah. I think it's thanks.
Also, may come to
Working
page
over a period of time.
2756. 7 paragraphs are relevant. I'm just reading a few of those.
46 report.
246 report, Justice A.P. Shah's report. It starts at para 53. It is universally accepted that any quasi-judicial process, including the arbitration process, must be in accordance with the principles of natural justice in the context of arbitration, neutrality of arbitrators viz. Their independence, impartiality is critical to the entire process. Then, my lord, 54, the test for the 12.3 has been set out. 55, my lord, is what was the previous position. Then, my lord, 56. The limits of this provision has been tested in the Indian Supreme Court in the context of contracts with state entities naming particular persons' designations associated with that entity as a potential arbitrator. Appears to be settled by a series of decisions in the Supreme Court. Then, my lord, your lordship leaves all the decisions that arbitration agreements and government contracts will provide for arbitration by a serving employee of the department valid and enforceable. While the Supreme Court in IOC Raja Transport carved out a minor exception when the arbitrator was the controlling or dealing authority, and this exception was used by the Supreme Court in so-and-so to appoint an independent arbitrator under Section 11, this is not enough. The balance between procedural fairness and binding nature of these contracts appears to have tilted in favor of the latter by the Supreme Court, and the Commission believes that the present position of law is far from satisfactory, since the principles of impartiality and independence cannot be discarded at any stage of the proceeding, specifically at the stage of constitution of the arbitral tribunal, incongruous to say that party autonomy can be exercised in complete disregard of these principles, even if the same has been agreed to prior to the disputes having arisen between the parties. There are certain minimum levels of independence and impartiality that would be required of the arbitral process, regardless of the parties' apparent agreement. Sensible law cannot, for instance, permit appointment of an arbitrator who is himself a party to the dispute or is employed by or similarly dependent on one party, even if that is what the parties agreed. So, my lord, there is a This is the logic of the Law Commission. Commission hastens to add, Mr. P.K. Malhotra, ex officio member of the Law Commission, suggested having exception for the state, allow state parties to appoint employee arbitrators. Commission is of the opinion on this issue cannot be any distinction between state and non-state. Concept of party autonomy cannot be stretched to a point where it negates the very basis of having impartial and independent adjudicators for resolution disputes. In fact, when the party appointing adjudicator state, duty to appoint impartial and independent, much more onerous, right to natural justice cannot be said to have been waived only on the basis of prior agreement between the parties, time of the contract before arising. Large-scale amendments have been suggested. Fundamental issue of neutrality, Commission believes is critical. In particular, amendments 11, 12, and 14. Your Lordships have seen those amendments. Then, my Lord, 59. Commission has proposed requirement of having specific disclosure to arbitrator, state as possible appointment regarding existence of any relation of interest of any kind, likely to give rise to justifiable doubts. Then they talk about the fourth schedule, the IBA guidelines. I'm not reading all that. Please come to 60. So the 59 distinguishes between de jure eligibility, ineligibility, and the seventh schedule, and then 60 is the exception. And Manoj, this exception now, according to railways, they have a clause where there's a format where you sign on a 12-5 agreement. So that is now presented to you initially before you, for you to waive. And many, my Lord, contractors then waive it. But that was not the purpose of this exemption. The Commission, however, feels its real and genuine party autonomy must be respected. Certain situations, parties should be allowed to waive even the categories of eligibility set out Provost Fisher. This could be in situations of family arbitrators or other arbitrations where a person commands the blind faith and trust of the parties. I don't think anybody can raise this to this level. Despite the existence of objective justifiable doubts, deal with such situation, Commission proposed a proviso to 12.5. Parties may, subsequent to disputes having been arisen, waive the applicability. The general rule has to be followed. If the High Court is approached in connection with an appointment of arbitrator, Commission has proposed seeking disclosure, so on, and which context or the designation is to have due regard of the contents of such disclosure. So this is the relevant portion of the Law Commission report. Now, would your Lordships look at the four judgments now, or should I put the material? Whichever way, my Lord.
Let's see the material and so we are done with that.
So, my Lord, I'm skipping those four judgments, my Lord. I just want to mention, my Lord, that we rely on certain paragraphs in your Lordship's judgment in Lombardy. And in particular, my Lord, we rely...
Why don't you cite those judgments then? And then we look at the material at the end.
Right, my Lord. There are four judgments which are in play, and Lombardy, my Lord, is the basis on which we have made our submissions. My Lord, the four judgments in play are, the first, I'm not going in chronological sequence, my Lord. There is TRF and Perkins, which are in respect of appointment of sole arbitrator. That's one category. Then there are two judgments. There is Core and a judgment called Voestalpine, which is the DMRC judgment, which is in the context of panel. So, my Lord, I will first show, I will not even, in the interest of time, my Lord, I will not show TRF. I will show Perkins, which then also reflects TRF. So, I will show Perkins, and then, my Lord, show Core, and then Voestalpine, which is some sort of, my Lord, halfway house. I want to show these three in that order, and then, my Lord, I'll make myself. First, if your Lordship sees Perkins. Perkins Eastman versus HSCC, 2019-17 SCR 275, tab 51 of volume 3, page 1254. This is the judgment your Lordships have been consistently following. I believe, my Lord, also in Glock, etc. This court has followed this.
That volume?
Volume 3, page 1254. Tab 51. The judgment dated 26/11/19, following TRF. This was, my Lord, an 11-6. In fact, all the four matters before your Lordships are at the 11-6 stage. No, in this judgment, one issue was whether it was an international commercial arbitration. That issue does not arise here. Please come straight away to paragraph 11, where the second issue arises. Before that, if your lordship wants to, this is para 11, where the second issue arises, page 1268. And the clause is basically the at 1269 D. The lordship sees that. Unless otherwise any dispute between parties in accordance with the agreement shall be referred to sole arbitration of MD or of buyer or his nominee. Venue shall be in Delhi. So this was the clause. Paragraph 14, my lord, TRF and ergo is quoted. 15 to 20 is relevant for our purposes, my lord. 15 starts at the bottom of page 1272. It was thus held that the MD became ineligible by operation of law to act as an arbitrator. He could not nominate another person to act as arbitrator. Once the identity of MD was lost, power to nominate somebody else, an arbitrator, also lost. Relevant clause in case had nominated the managing director himself to be the arbitrator, also empowered the MD to nominate another person to act as arbitrator. MD thus had two capacities: first as arbitrator, second as an appointing authority. Present case we are considered with only one capacity. Then we thus have two categories of cases. First, similar to one dealt with TRF, managing director himself is named as an arbitrator, additional power to appoint any other person. You know, this, the finding, I'll just read this one. Appoint any other person of his choice or discretion as arbitrator. If in the first category of cases, MD was found incompetent because of the interest he could be said to have having in the outcome or result of the dispute, element of invalidity directly relatable arise from the interest he would be having in outcome of the decision. That be the test. Similar invalidity would also arise and spring even in the second category. Interest he has in the outcome likely to be taken the basis possibility bias always be present, irrespective whether matter. We are conscious that if such deduction is drawn from decision so and so, all cases having clauses similar to that with which we are presently concerned, party to the agreement would be disentitled to make any appointment of arbitrator on its own, always be available to argue party official having disentitled. But in our view, that has to be the logical deduction from TRF Limited. Para 50 of the decision shows that this court was concerned with the issue whether the MD, after becoming ineligible by operation of law, still eligible to nominate an arbitrator. Ineligibility referred therein was a result of operation law. Person having an interest in the dispute, outcome of decision therein must not only be ineligible to act as an arbitrator, not be eligible to appoint anyone else as an arbitrator. Such person cannot and should not have any role in charting out any course to the dispute resolution by having the power to appoint an arbitrator. Will not we rely on this portion. The next sentence in the paragraph further shows that in cases where both parties could nominate their respective arbitrators of their choice, this is the critical portion, of their choice, were found to be completely different situation. The reason is clear that whatever advantage a party may derive by nominating an arbitrator of its choice would get counterbalanced by equal power with the other party. This is the section, this language is essentially, 18 language, because this is arbitrator. This is a classic case, I appoint one arbitrator, the other side appoint none. But in a case where only one party has the right to appoint a sole arbitrator, its choice, so my lord, your lordship will apply this logic to the panel, will always have an element of exclusivity in determining or charting the course for dispute resolution. Naturally, the person who has an interest in the outcome of the decision must not have the power to appoint a sole arbitrator. That has been taken as the essence of the amendments brought in TRF. Then, my lord, 17. So this is the critical paragraph is 16. 17, my lord, Raja Transport is mentioned. This is a pre-amendment case. The relevant portion of 17, your lordships, will come to page 1276.
So, Mr. Banerjee, the proposition is that your choice to make or nominate an arbitrator cannot be limited to the offerings laid out by one party.
That's our case.
So
that's our
in, in a situation like this, it is not a choice that is being exercised, but you are confined to the offerings that is given by the other side.
Correct, correct. It's a poisoned well. It's a limited, my lord, it is.
But it's again a matter of perception. Somebody from amongst the panel can also render an award against the, the
And
authority
Lord,
which has made
That is,
the.
in fact, that is exactly what happened. The panel in the DMRC case was of 3 engineers nominated from the railway panel. The same clause, which your lordships dealt in DMEPL, is the same clause where 3 are nominated. 1 I pick from theirs, 2nd they pick from theirs, 3rd they pick from theirs. 3 members may go that way. My lord, there are all sorts of problems with that also. Therefore, my lord, this limited choice is where I should have my liberty, they should have their liberty. Alternatively, neither should have liberty. We go to somebody independent, and that either it is an institution which is independent and appoints in which you believe, which has credibility, or the court who appoints somebody independent. Then I don't have a problem. They don't have a problem. Neither of us have a problem. Even if the award goes against me, the tribunal, my lord, it's a matter of faith. Every case we come across, you scratch at the surface. The main problem is.
Banerjee, the only point is just reflect on it. Yeah, I don't know whether that consideration is at all relevant. Is there a risk of killing the golden goose in the sense that what do government say? We are not going to go to arbitration at all.
My lord, they have themselves set up institutions. It's not that there are no institutions available to them. My lord, they have themselves set up institutions. Surely somebody has to be believed. My lord, that there has to be some, either you believe the courts or you believe your own institution. It can't be. I follow, my lord. That is exactly.
This judgment is over.
Yeah, my lord, just one last paragraph. This is what just above 18. 18 is, this was the.
Judgment.
Yes. Well, not this judgment also is very helpful because it quotes some portions of Voestalpine. So I'll just place it from here.
Yes.
Monod, please come to para 18, Monod. I just want to read 18 for 1 second, Monod. Sure. Sub-paragraph, this is in fact, even the old law. 8 of the aforesaid paragraph 48 lays down, Monod, please just read that. 8, just above. If circumstances exist giving rise to justifiable doubts as to independence, impartiality of the person nominated, or if other circumstances warrant appointment of an independent arbitrator, by ignoring the procedure prescribed, Chief Justice may ignore the designated arbitrator appointment. So, my lord, if circumstances warrant appointment of an independent arbitrator, even prior to the amendment, and that is what your lordships have said in para 66 of Lombardy, you for the purpose of appointing an independent arbitrator, you have the power, indeed the duty under 11A to do it. And that is what was missed in court. If somebody has approached a court can't say, this is the procedure, I am a post office, this is exactly what I have to do, you please do this. So, my lord, 11, this paragraph is relevant. Then, my lord, various quotations are there. Then 19 is Voestalpine. These are very, my lord, hard-hitting paragraphs, 20, 21, 22, and 30, which has been set out in Voestalpine. So the DMRC case. Independence and impartiality are hallmarks of any arbitration proceedings. Rule against bias, one of the fundamental principles of natural justice, applied to all judicial, non-judicial. So this relation, notwithstanding fact relationship, is contractual. Source of arbitrator is deduced from the agreement. Notwithstanding same, non-independence and non-impartiality, such arbitrator would, though commercially, would render him ineligible. Genesis behind the rationale, even when the arbitrator is appointed terms of contract by the parties of contract, he is independent of the parties. Functions and duties require him to rise above partisan interests of the parties. So this is, my lord, one portion where Jivaraj and Hashwani is quoted. And similarly, my lord, the French court is quoted. Then 22. Independence and impartiality, two different concepts. Arbitrator may be independent, yet lack impartiality. Impartiality is more subjective. Independence, more objective concept, straightforwardly ascertained by the parties at the outset in the light of the circumstances. Partiality will more likely surface during the arbitration proceeding. Then, 30. Time has come to send positive signals to the international business community in order to create a healthy arbitration. Furthermore, as enlightened by the Law Commission, duty becomes more onerous in government contracts. One of the parties is a public sector undertaking itself. In the instant case also, choice is given by DMRC, limited to choose an arbitrator from panel, becomes imperative. This is the broad-based panel argument. I'll come to that later. In the light of report of so-and-so, imperative of creating healthy arbitration, then that's all that is relevant in this judgment. The rest is on maintainability, etc. So this is...
Mr. Banerjee, can we just take a 2 or 3 minute break? I just suffered from a lower back ache last week.
Please.
For 2 or 3 minutes, I just want to take a little break and come back. That's all. Just walk a little bit in the passage and come back. Just 2 or 3 minutes. Yes.
No, I've had a little rethink. I'll show the core judgment and the Voestalpine judgment later. Let me first show the material, because those judgments in any case your lordships will have to consider. But let me, my lord, since I'm showing the material, and let me show the material as to what is on record. One of the first proposition is that party autonomy is not unfettered. There are some mandatory provisions. And my lord, for which purpose your lordships are permitted to, or permitted, well, I wouldn't say required, to look at the preparatory material, which is the basis of the article, which is then the basis of the section. Well, not in fact, very interestingly, when the UN General Assembly recommended the model law to us, to all the countries, it asked the Secretariat to send the travaux préparatoires along with it. That resolution, my lord, is one page, it's on record. Lordships may just see, which is why, my lord, we are relying on the travaux. That is volume 3, serial number 162, page 5015. It makes very interesting reading. This is the General Assembly resolution by which model law was recommended. 5015. Sorry, volume 4.
Volume 4.
4.
Model law on international commercial arbitration at UNCITRAL. Is that
Volume 3, madam.
Volume 3.
Volume 3.
Volume 3. We've got it. Volume 3, 5015.
No, this is the General Assembly resolution.
The General Assembly resolution.
I'm not going to read the whole thing, but please see, after being recognizing, convinced, noting, convinced, requests the Secretary General to transmit the text of the model law together with the travaux and and recommends that well, this is the resolution
Column, left column.
What's the page again, Mr. Ben?
pages 5015.
Left column?
Under the General Assembly.
Yes, General Assembly 40th session 40/72 model
The General to transmit the text of the model law
along with the travaux and recommends that all states give due consideration. So they actually, my lord, not only sent the text, but they also sent the travaux. That's the only reason I'm. But it gives you the basis, my lord, as why it is to be referred to.
Yes.
So, my lord, the first proposition is that there are certain rights which are not waivable. And I had shown your lordship article, section 4 and section 34, which uses the word derogate. And the commentary on that, my lord, is at volume 4. I'm only going to show 2 or 3 pages, my lord, not more, just to fit it in. Volume 4, serial 145, page 10149 at 10150. This is a 10150 is, my lord, 10149 is the cover of my lord.
Volume 4 is it?
Where's the book? My lord, what has happened is the material is spread over large portions of the website. There is a textbook, my lord, which is this Holzman and Neuhaus, which actually chapter wise analyzes each article. My lord, 10150 is the same as section 4. Please see the third paragraph.
Okay.
Third paragraph, second sentence, Secretariat's commentary on Article 4 makes it clear that in case of requirement of the arbitration agreement, that stipulation must be valid and in particular not in conflict with the
We are at 10150.
10150, not commentary.
Correct.
Please see the item 1,
The second
non-compliance with arbitration agreement or non-mandatory provision.
What? Compliance with arbitration. Yes.
Procedural default at issue must be a breach of stipulation in the arbitration agreement or a non-mandatory requirement. Secretariat's commentary on Article 4 makes it clear that in case of a requirement of the arbitration agreement, stipulation must be valid and in particular not in conflict with the mandatory provision. And the footnote gives the Secretariat, and that's also on record. So this shows, my lord, that there is a mandatory provision. Then, my lord, please come to 10151. bottom of the page. Second sentence.
015?
Next page, next page. 10151.
Yes.
Last bottom, Malone. A waiver under Article 4, however, applies only to the non-mandatory provisions of law, that is, those provisions upon which the parties may agree to the contrary. This qualification, not part of the initial draft of provision, specifically included to soften its effect. Proposed at one point to provide a list in the law of such mandatory provisions, working group decided not to include such a list because it viewed it unnecessary subject to certain drafting difficulties. Nevertheless, a number of provisions clearly indicate their non-mandatory character, either by providing explicit freedom or providing a rule of procedure but stipulating parties may agree otherwise. Examples of provisions appear to be mandatory and therefore cannot be waived under Article 4 are the following. Requirement: the arbitration agreement is in writing. Well, I rely on the next one, the requirement that the parties be treated with equality, each party be given full opportunity to presenting. So Article 18 is mandatory, my lord. There's a judgment of our court in Vedanta, which also says that it is mandatory. It is, my lord, 18 cannot be derogated from. That's the only reason, my lord, I'm showing this. Then, my lord, this is the commentary on Article 4. Your lordship may now see the commentary on Article 34. That's the other place where the word derogate is used. The commentary on Article 34 is at page 10054, serial number 144, little behind. 10054. This is tab 144, my lord. That's the book, Malone. And just one paragraph I'll show at 10061. This is a little important because, Malone, there is a judgment which seems to suggest a little differently, but I'll just read it. The second significant change was made to subparagraph 2A4 of Article 34. Corresponding clause of the New York Convention, Article 51D reads, the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties, failing such agreement, not in accordance with the law of the country where it was made. The final text of the model law includes a new phrase following the first comma, unless such agreement was in conflict with the provision of this law from which the parties cannot derogate. History of this new phrase becomes footnote. Please come to the next page. I'm not reading may I just read this one? Because it is of some relevance on mandatoriness. The history of this new phrase begins in a footnote to the Secretariat's initial draft, what became Article 36, incorporated by reference to early drafts of 34. That footnote noted that the view then prevailing amongst commentators was the language of the New York Convention gave absolute priority to the agreement of the parties, irrespective of whether such agreement is in conflict with a mandatory provision of the applicable law. Secretariat said here that this rule could not possibly apply to the enforcement of domestic awards, kinds of awards which Article 34 is concerned. Presumably, domestic courts would be, by definition, be bound to apply the mandatory provision of domestic law. Working group agreed, and my lord, I skipped that paragraph, then last paragraph. During the Commission's consideration of the working group's final draft, which was the same as the final text, a potential ambiguity was noted by several delegations. They said that the provision might still be interpreted not to allow an award to be set aside where the procedure set forth in the arbitration agreement had been followed, but where that procedure conflicted with the mandatory provisions of law. While no change was made in the text of the law, the Commission report recorded the understanding that where the agreement was in conflict with the mandatory provisions of the law, provisions will prevail. So, my lord, and that's the same section which your lordships have seen this morning, 34 2A5. Composition of the arbitral tribunal, arbitral procedure was not in accordance with the agreement of parties unless such agreement was in conflict with the provision of this part. So, my lord, 34 2A5 specifically addresses a situation where the composition of the tribunal may be in agreement, my lord, in our case, may be in accordance with what the parties say, but if it is contrary to a mandatory provision of the law, it should be set aside. And that's, my lord, what the commentary says.
Yes, sir. Deals with a situation where the composition
that was the intention.
with
My lord, there is some ambiguity in the language of 34(2)(a)(5), and it was brought to the notice of the commission. The commission says that obviously mandatory, if there is any mandatory provision, even
That will
if
prevail.
right, there is a directly opposite judgment to this. This was not cited before a 3-judge bench. There is a judgment of your lordships which says exactly the opposite, and it is my duty to bring it to your lordships' notice. Where the argument which is accepted, which is rejected, is mandatory overrules contract. Argument is even if it is contrary to a mandatory provision, still the contract will prevail. I'll give your lordship the reference, my lord. It is Narayan Prasad Lohiya. It is at page 681. If I don't show it, my lord, it will be unfair, my lord. There is a judgment which says the opposite. I must show it.
Volume 3, page 681.
Sorry, my lord.
Volume 3.
Volume 3, page 681, my lord. Tab 22. Actually, this reasoning was probably unnecessary in this case, my lord, because it was held that it was a derogable provision. But still, this reasoning is there, my lord. 681, and the relevant portion is at 695. Lords, if your lordship sees 695 is what Mr. Venugopal argues, which is consistent with, my lord, what I showed from the working group, my lord. So Mr. Venugopal's argument, my lord, which I commend for your lordship's acceptance, is 695, my lord, page 11.
Read between placidum B and C. In other words, according to Mr. Venugopal,
even if the composition is in accordance with the agreement, award can be set aside if it is in conflict with the provisions of Part 1. This is what he argued. Now, that is rejected by the court, and it is held at page 6, that entire paragraph is there, at 696, last sentence. Thus, so long as the composition of the arbitral procedure is in accordance with the agreement of the parties, Section 34 does not permit challenge to an award merely on the ground composition of the arbitral was in conflict with the provisions of Part 1. This also indicates that 10 is a derogable. Not here.
Where was this, by the way? 690?
6, last sentence of the first paragraph.
Oh, just
so,
as long as the composition of it.
The judges don't notice that, my lord, there are derogable provisions and
non-derogable.
So if it is non-derogable, you cannot, my lord, contract out of law. So, my lord, I just want to show. So, my lord, the first proposition is there are certain certain provisions of the Act which are non-derogable. Non-derogable is also a clumsy word, which are mandatory. Not the language uses mandatory. Two provisions which I have said are mandatory. Your lordships have already noted 11(8), 12(5), and 18. Now, the third point is, my lord, 11(8) has to be read with 18. My lord, this is one aspect which the third point, my lord, I would say is 11(8) permits for a diversion from the agreed procedure, for which I just want to show your lordship 3 or 4 paragraphs of Lombardy. Just 3 or 4 paragraphs in Lombardy. 11(8) permits this diversion. So, my lord, if your lordship just sees Lombardy, I'm not going to read it. Your lordship, 3 of your lordships are party to it, familiar with this. Lombardy is at volume 3, page 2058. Various issues are framed, my lord. I am not going to go into it. It is that issue regarding, my lord, pre-deposit. Please first see paragraphs 81 onwards, my lord. 81.
Citing SCR.
SCR.
All the juniors have put SCR together
SCR.
because now all our judgments are in the digital form and digital SCR. Yes.
Earlier, I remember at least in the 90s,
You couldn't cite
you
anything,
could
but
not
you
cite
could not
anything
cite
else. It
the
was
only official report.
unless you had the judges would not even recognize an SCC or a let alone scale or something. It only
SCR couldn't keep pace, that's why others.
that's why this problem came.
Now it's
Now it's caught up.
up to date.
In fact, your lordship's direction is that they have to file only SCR copies. My lord, make straight away come to page 2105, para 82. 82, my lord. Bottom of
At page
2105. So, my lord, if I am right, the arbitration agreement has to be consistent with, my lord, 11, 12, and 18. And then, my lord, 84 is concept of party autonomy cannot be stretched. And then, my lord, 86 and 87. That's all I want to show. There are other paragraphs, but in the interest of time, my lord, I'm not showing the other paragraphs. The 86, 87 are page 994, my lord. If circumstances give rise covers composition. After all, 18 may not cover composition. It may be after the tribunal is formed, everything else. Why should it cover composition? Now, Manoj, there was some doubt on this. There are two parts to the commentary. I'll show both, and I'll show, my lord, what is the understanding generally. My lord, may first see on 11. It's very interesting, my lord. It reads, shall we say, my lord, both ways? Shall we say, my lord, both ways? Here's the 11th commentary. Hmm? Which one? Oh, no, where is the commentary? Lordship, just give me 1 second. 10. Where's the 18? My lord, may see the 18 I'll show the 11 first in fairness, and then I'll show 18. My lord. 11 commentary, my lord, is at Well, now I just want to show you lots of the material on Article 11 and 18, and then I'll continue. On 11, so discovery of Mr. Nariman Mulot, this is the Clout Digest.
In fact,
He was to argue that.
This was the last submission which Mr. Nariman drafted and emailed it at about 12 noon, the day before he passed away, the night before he passed away.
In
He
fact,
was working on this.
A lot of the material that I'm citing
away.
was his independent research, Mulot, and particularly this one. So a lot of it was done by him.
From Mr. Well.
Mulot may come to volume 4, 3807. This is part of the Case Law on Ancestral Text Digest. Mulot. There is a there is a site which collects case law on ancestral text. I am one of the, all of us are correspondents from India. 3807. It's a summary at paragraph 20. This is the purpose of 11. Purpose of 11 is the key purpose of 11. Paragraph 20.
Article 11 corresponds to
Section 11. In fact, it was Article 6 and 11, but 11 corresponds to 11. Exercise of the courts or competent authorities' discretion. Securing an independent and impartial tribunal was said in one case to be the major objective that ought to be pursued by the court or competent authority intervening on the basis of 11. While in another case, it was said to be the paramount consideration. It has also been explicitly identified as an important consideration in several other cases. And footnotes, the cases are also on record. So, my lord, when your lordship looks at section 11, this is one major aspect to be looked at. It is not simply procedure, appoint whoever is said on the panel, simply appoint. Major consideration is impartiality and independence. This is generally the law in respect of 11. That's why you give this power to a court or an authority. Otherwise, not anybody else could have.
21, they refer to qualifications. If qualifications are provided, the court cannot change the qualification.
Right.
If a lawyer, if a physician has to be appointed,
I'm relying on 20. I'm relying on 20.
You cannot appoint a lawyer.
I'm relying on 20, para 20.
Right.
20 says that this is the objective, namely independent impartial tribunal. This is the major objective. This is the paramount consideration. One says major, one says paramount. So, my lord, when your lordships are construing 11, otherwise, what is the joy of coming to, my lord, a court or an authority?
Right.
You are essentially the arbitral tribunal as a substitute. In the, it's an alternative dispute resolution. It's a substitute. So, this is, my lord, one aspect. Now, please see commentary on 11 and commentary on 18. Commentary on 11, my lord, is serial number 141 in volume 4 at page 10040.
It's from the same book, right?
This is the book which has all the extracts.
Tell the number again.
40. Same one.
Tab kya hai? Tab 141. 10040. Article 11 is there, my lord. Please come to page 10042 at the bottom. I just want to read this a little carefully. Paragraph 2 of Article 11 does not state any limitations on the parties' freedom to agree on a procedure for appointing an arbitrator or arbitrators. The provision does state that the freedom is subject to the provisions of paragraph 4 and 5 of this article, similar to ours. But those paragraphs only provide for supplementary intervention by the courts in case the agreed on procedure fails to work. They do not place any express limitation on the parties. Nevertheless, in drafting paragraph 2, it was recognized that the model law as a whole implied certain restrictions on the parties' agreement regarding appointment of arbitrators. The third working group cites examples, 2 articles that give rise to such restrictions. Article 12 concerning grounds for challenge, Article 34 concerning the court's power to set aside arbitration. Thus, for example, if the procedure agreed on results in arbitral tribunal fails to meet the standards of impartiality and independence, arbitrator will be subject. Similarly, if appointment results in a party not receiving proper notice, an award may be set aside and refused recognition. These are specific restriction contained the model code, go to the effects of the procedure. These restrictions result the results of the selected appointment, not the procedure itself. Thus, the arbitration agreement does not provide for proper notice. Then, 11. Next para. The working group considered at some length adding to Article 11 an explicit limitation on the parties' freedom to determine the procedure for selection of arbitrators. Provision would have stated procedure agreed upon parties would be invalid or to the extent that it gave one party predominant position, on the words of an alternative draft, manifestly unfair advantage with regard to the appointment of arbitrators. This provision was later deleted. One, problem did not arise frequently. They were not probably aware that the problem arises very frequently here, but that was their understanding. Two other provisions of the law, and we rely on this. Other provisions of the law, such as 12 and 34, could be used to address the problem. Wording was regarded as too vague, could lead to controversy, dilatory practice, potentially invalidation of well-established, recognized appointment practices, while the working group concluded that such a provision had no place in the model law, and the final text accepted by the Commission confirms that decision. The working group did note that its determination should not be understood as expressing support for unfair practices. And my lord, I just want to show what exactly it said is at page 9998 of the same volume. Serial 1, I want to show the sentence actually which the working group used. Serial 137 at 9998. Paragraph 89, 90, and 91 is basically what is summarized in the book. The working group, 91 I'm reading, after deliberation decided to delete paragraph 2. That decision, however, should not be understood as condoning practices where one party has a clearly greater influence in the appointments without good reason. So, my lord, this was definitely something which weighed with the working group. So, my lord, this is when 11 is debated. Now your lordship goes a little further. So now the debates continue and 18 is debated. Now by the time 18 comes along, there is a little shift. Now your lordship will see the commentary on 18, which is very interesting. Just a minute. 1 minute. Have you shown this? I've shown 11. 11 is over. My lord, may come to Article 18 commentary.
It was not because they accepted such clauses, but
Correct.
they felt that the other provisions would be sufficient to deal with them.
Now, my lord, 18 commentary is very interesting. Please come to 10050. Serial 143, no, tab 143.
The previous one which you showed is part of which document?
The previous one is an extract from the
Okay.
It's tab 137, my lords, at page
Got
982.
It is
Got it, just one.
it is actually part of the report. That's the language of working group report.
We are at 10050.
10050. Now, my lord, I'll just read. This is makes very interesting reading. Article 18 establishes fundamental principles. All arbitrations must be treated with equality. My lord, then it mentions Magna Carta of arbitral procedure, due process clause, etc. Then, my lord, second paragraph. In early drafts of the law, provision that now constitutes Article 18 was included as the third paragraph 19, to which, as discussed below, it's an important corollary. In order, however, to emphasize the central importance of the principle of equality and fairness, intention they apply to the entire arbitral proceedings, Commission decided they should appear in a separate article. Now, my lord, I'm not reading the next paragraph. I'm just reading maybe 10051, top one. Article 18 is thus the limitation on Article 19, which provides broad autonomy, first to the parties and second, in the absence of party agreement, to the tribunal to decide on the procedure to be followed in conducting the arbitration. Now, my lord, the point which has been raised by your lordships is addressed at 10050 5(2). The precise scope of application of Article 18 may give rise to some question. Lordships have this 10052. As noted, the Commission report states that the tenets of Article 18 are applicable to the entire arbitration proceedings. For this reason, Commission moved the provision from 19.3 into a separate article at the beginning of Chapter 5, which concerns the conduct of proceedings. In addition, I rely on this. In addition, the Secretariat stated that the provision applies even more broadly than the 9 other articles of Chapter 5. In urging the Commission to adopt the quoted interpretation, the representative of the Secretariat stated, it has always been the understanding of the working group that the fundamental principle enunciated in 19.3 article would apply to arbitral proceedings in general. It would govern all provisions of Chapter 5 and other aspects such as the composition of the tribunal not directly regulated therein. So, my lord, though one interpretation could be that it would be a very truncated interpretation. It means the tribunal is set up which is not impartial, or there is no equality between the parties, but they behave impartially. So, my lord, even the procedure of composition of the tribunal falls within that period. So once you go, till the time you don't go to a forum, you can negotiate your rights. It may be one-sided contract. Once you go to a forum, which is a substitute for a judicial forum, then, my lord, this you can't really have not a level playing field. And therefore, my lord, their understanding was that the composition is also, my lord, something which is covered. And, you know, this is one part of it. The commentaries also say this. I'll show the commentaries now, my lord, and that will also make it clear, my lord. First, if your lordship sees, these commentaries are also referred to the, my lord, just, my lord, may first see well, Lord, Peter Binder is at page 10185, serial 147, the same volume. Happily for me, all this is reflected in the learned SG's submissions also, much of this. Section 18 is also relied on by him. We were, my lord, happy to note that he's also relying on it. I thought it might be a little difficult. Please see page 10186, my lord. This of course is in the context of uncitral arbitration rule. Equal treatment of the parties in the appointment process, due to the fact that it is primarily up to the parties' agreement to decide who should be the arbitrator in any given case. Also due to the fact that under 8.2, parties may determine how the appointing authority is to find a candidate for the position of arbitrator. It is important to keep in mind that the rules, as well as most national laws, Article 18 of uncitral modern law, place paramount importance on the equal treatment of parties in the arbitral process, means that no party may be given preference in the arbitrator selection process, regardless of how strong the bargaining power may be. This both in the process agreed on by the parties or in the process chosen by the appointing authority. Any violation of this principle could lead to a setting aside of the arbitral award for violation of this fundamental principle. This is one view which is given in Binder. And then, my lord, one more. I'll show there are a number of others. I'll just show one more. My lord, serial number 148, page. This is Fouchard, my lord, 10189. Just 10189, my lord. At 10191. Three, limits on the primacy of the parties' agreement. 783. The primacy of the parties' agreement is not absolute. It is limited in some respects by the requirements of the proper administration of justice. 784. Certain of these limits have already been outlined and will be discussed later at greater length.
Sorry,
10191.
10191.
Limits of the primacy of the parties' agreement.
Yes.
Primacy of the parties' agreement is not absolute, limited in some respects by the requirement of the proper administration of justice. Certain of these limits have already been outlined and will be discussed later at greater length. They are the arbitrators' independent impartiality. That was my first submission. Others result from the requirement that the parties' method of appointing the arbitrators or the institutional rules chosen comply with the fundamental principles of due process. These principles include, in particular, the parties' right to fair trial and their right to equal treatment. Latter is expressed in the uncitral model law, Article 18 of which states the parties shall be treated with equality. Dutch law is also mentioned, German law is also mentioned, and those are quoted. They are much more, specific. So, these, in fact, in the recommendations by the expert committee, we have suggested similar amendments to be made to the relevant provisions. So, 18 in our respective submission is also a ground on which this clause, can be held to be contrary to the provisions of the Act in view of the observations in Lombardy. And, therefore, under 11.8, because there is evidently unequal treatment of the parties, it's a given deal. In fact, the entire language of Voestalpine and the entire language of even core is that you balance. So balance is only when there is equality. So this is so far as this is concerned. And one other very interesting judgment I want to put, and then I will come back to core and conclude. One aspect of this, so whether your lordships put it in the impartiality independence category or equal treatment category, the approach taken in the US is on the basis of unconscionability. Here also, my lord, we are grateful to the learned solicitor. 10 cases he has summarized in his written submissions. 10 such judgments he has summarized. I will show what I would submit. We had filed 3 or 4. Some others are there. I will show one judgment, because this issue of panel and one party controlling a panel has arisen in multiple cases in the US with multiple, this thing. I will show one, maybe if your lordships indulge, 2 cases which are very instructive. Lordship first sees serial number 140. Volume 3, page 4294. Austin Trout, my lord, 4294. Tab 140 versus the boxing organization. This was a professional boxer who wanted to avoid the clause in the WBO agreement. Tab 138. I'm so sorry. Please come straight away to 4301. Roman 5. That brings us to Trout's last challenge, in which he takes aim at the district court's ruling by focusing solely on the arbitration selection process that the appeal regulation set forth. Trout contends correctly that the provisions grant the WBO exclusive control over the appointment of the arbitrators who will decide his case. Under its plain terms, the WBO could even appoint its own employees, including direct aides to the head of the WBO, in the arbitral panel with no input from Trout. In consequence, Trout argues that the arbitration agreement does not provide him fair opportunity to pursue either his claim under so-and-so or his claim under so-and-so arbitrator by virtue of the method of selection would be inherently biased. Then, my lord, he cites a case which is distinguished, and your lordships come to 4302. But Trout's contention that the arbitration agreement is unreasonable and unjust just because the arbitrator selection process permits the WBO to act both as party and judge has obvious force, notwithstanding that he does not identify any direct authority in support of his contention, arbitration agreement may not be enforced. Nor does WBO contend that Trout has forfeited or waived any agreement against enforcement. Instead, the WBO takes on argument about on its merits, and then, my lord, on this ground, there is further reasoning, and ultimately the court holds that this is a clause which is not inherently problematic and allows the appeal on that point and leaves the question of remand. These were the only two relevant paragraphs there. My lord,
This is only contention.
Sorry?
Where is the finding?
One of the I'll just show them. No? One of the finding is
See, paragraph 14 at page 4305, they don't deal with the issue actually.
Yes.
just a minute.
In determining whether the arbitration agreement should be enforced,
Right.
absent the invalid arbitrator selection mechanism,
They
and if it should, how to select an arbitrator, however.
that
We must
second portion
consider
is not
parties'
there.
intent, the federal policy favoring arbitration, and the interplay between state law and federal policy. But the parties have not fully engaged with those factors or the applicability of the savings clause. We therefore leave it to the district court to determine in the first instance whether the arbitration selection provision at issue here is severable from the.
That's the second question. On the first question, they hold that the provision is not valid, but on the issue of severability, my lord, they remove. My lord, please see the second judgment, which is very clear, my lord. McMullen, which is 139, serial number 139, 4307. Two critical paragraphs, my lord, paragraph 9 and paragraph 10. 4307 at 4314. What
Court is this?
43149. Therefore, we must decide whether, this is an extreme case, Mayor's TAP provides McMullen with an effective substitute for the judicial forum to pursue her Title VII claims. The TAP adopted by Mayor is commendably fair, except in one important aspect. It grants Mayor unilateral control over the pool of potential arbitrators. This is a case. This is not a case of retired employee, etc. This is a otherwise fair panel. Then, my lord, the first judgment relied on by McMullen is on Hooters, and that is discussed. I'm not going to read Hooters and Floss, my lord. They are all discussed here. Please come straight away to para 10.
Sixth Circuit decision to see, right?
Just a minute, I'm sorry, Manoj. Please come before that to page 4315. Mayor's TAP is plainly even more even-handed than the arbitration agreement at issue in Hooters, which allowed for unfettered employer control over the potential arbitrator, contained a myriad of unilaterally biased clauses giving Hooters an advantage in every way. But the arbitration selection process provided under Mayor's is less fair than the arbitration process described as Floss is fundamentally unfair. Then, not Floss is discussed. Then at the bottom, the type of control exercised by Mayor over the potential arbitrators is analogous to the exclusive control over the entire panel exercised by the employer in Hooters and rejected by the Fourth Circuit. Furthermore, the arbitrator selection procedure used by Mayer allows it to create the type of symbiotic relationship with its arbitrators that we feared would promulgate bias in floss. The risk of bias inherent in Meyer's procedure is demonstrated by the fact that Meyer uses the same panel
Let
of
me, because I look at it. You want to now the core because you have 5 minutes, then we'll wrap up at lunch.
right. So, my lord, on this basis, it is held that it is not a my lord, effective substitute.
Fair enough. Now
Because-
let's go to core.
Now, my lord, I'll just show your lordship score, and then I will just 2 or 3 lines I want to say at the end. My lord, may look at core. I have not shown your lordship's voestalpine because there are number of paragraphs
Voestalpine was in fact cited in Perkins.
in per.
Para 19 of
Right,
Perkins.
My lord, may come to core, which is at tab 52, page 1284 at 1289. My lord. My lord, in this case, the Allahabad High Court had appointed an independent arbitrator. But the Supreme Court reversed that and stuck to clause 64. Your lordship may first see clause, the heading. One of the first heading is from paragraph 12 to 22. It starts at page 1293. Para 11 to 22, my lord, is appointment of an independent arbitrator without reference to the clauses of the GCC, whether correct. My lord, my short reply to 11 to 22 is, it does not consider voestalpine. It does not consider 11.8. It does not consider the amendment to 11.8. It does not consider the fact that there is a necessity for an impartial tribunal, though all this was there in voestalpine. So, my lord, the problem with the first finding that this honorable court says you stick to the clauses, it does not consider the developments post 2015 at all. In fact, it relies on a judgment in Parmar, which is a pre-2015 judgment. And not even, my lord, noticing that even on pre-2015, you were required to have an impartial trial. My lord, please see the clause. It's a wonderful clause, my lord. Clause 64 is at page para 15. And the relevant portion is 1297. This is what is, my lord, the clause. This is the similar clause is there in the first 4 matters. The fourth
The
matter,
post-amendment clause, no?
sorry, my lord.
This is the post-amendment clause.
This is the post-amendment. Pre-amendment, my lord, I am leaving. This is the post-amendment clause.
Right.
Well, this is the clause which all railways and railway undertakings, BMRC, DMRC, etc., all the 4 cases before my lords. JSW is even worse because it has one unilateral arbitrator, but all of them have some variation of this clause. And the clause is, my lord, I am not on retired or my lord, serving. The panel has
Where is that clause?
the clause 1297, 64 3B. In fact, my lord, it's quite interesting. First, they present you with a clause which says you please waive 12.5. They've already got a format for that. So if you're not in the business with them, then you waive 12.5 and you will not suffer the consequences. They have a set format for that. But if you don't, then you come to this. For this purpose, Railway will send a panel of at least 4 names of retired officers empaneled to work. So the panel is unilateral. Contractor will be asked to suggest at least 2 members out of the panel. GM will appoint 1 out of the 2. Balance 1 from the panel or from outside the panel, presiding again to be appointed. So all 3 effectively, I choose 1 out of 2. 1 and the other 2 they appoint, even the chair they appoint. So all 3 effectively are the source comes from them. If this is the panel, my lord, I ask myself, either way you will not get justice. This is completely unworkable. In fact, the learned
Has
SG
anybody
seems to-
ever done an impact assessment
this
of the number of awards? Invariably, despite all these,
They all
many of
go
the
in favor
awards
of
have
the
gone in favor of the
contractors.
contractors, hardly any in favor of.
and that
You
makes
know
it my lord,
about
much worse. According
The
to
reality is that.
that makes it much
Theoretically
worse,
is
my lord,
all right.
because that actually makes it much worse, my lord. If that
This
Realities are very
clause,
different. Sorry.
put the party at a serious disadvantage so far as choice of.
there is, my lord, it is
arbitration
usury.
concerned.
There is no choice. In fact, the learned SG has conceded in his note that core is wrong. My lord,
One, you have to appoint your arbitrator. You means the claimant from out of the panel suggested by the railways. Two, the other two are appointed by the
yes,
railways.
yes,
And
that's,
chairman also.
So the
by the way.
chairperson is appointed
that's
by
the clause, my lord. That's the standard clause.
Only difference between pre and post is that earlier they were gazetted officers. Now you have retired officers in the panel.
That's the only.
That's the only distinction.
So thank you, Mr.
15 minutes, 10 minutes.
Now we'll wrap up. 1
10
o'clock
minutes.
means 1 o'clock.
Go by the schedule.
1 o'clock means 1 o'clock. At 2 o'clock, we'll hear Mr.
I will just summarize in literally in 5 minutes. I will not show any document.
No, give us a small note after
Hold on,
lunch.
just
We'll-
five
no,
minutes or not.
uh,
5
we-
minutes.
no,
It's 5 o'clock. 5
Here,
minutes.
2 o'clock now, Mr. Paul. Thank you.
I'll start. Okay. Yes, sir.